Hi, my name's Alex Dolphin. Welcome back to another episode of Ex Ante. Today we're going to discuss the case United States v. Armstrong. This case started in the Supreme Court of the United States in 1996. Let's go ahead and jump into the facts of the case. So some men were prosecuted for possession with intent to distribute of controlled substance, that controlled substance being crack cocaine. These men were prosecuted in federal court, and these men were black men. These black men argued at the district court that this was a selective prosecution, meaning that they were specifically targeted by the prosecutor, by the United States attorney, because they were black, and this was unfair because other people that were white or other races were not being prosecuted for their possession of crack cocaine in federal courts, rather they were being prosecuted in state courts. And so their argument was rooted in the Constitution, rooted in the 5th and 14th Amendment, and the equal protection clauses therein. This argument basically is that if you are prosecuting on the basis of race, religion, or some other arbitrary characteristic, well, then the government can't do that. They have to prosecute everyone fairly. And so this fits in with this large bucket of prosecutorial discretion, and this is one boundary that the Constitution places on the executive, saying that hey, you can't prosecute people based on their race. You can't prosecute discriminatorily. You have to be fair in the way you execute the law. So this is the argument of the defendants, and they're saying this is selective prosecution. The district court says, you know what? You have an affidavit. These men produce an affidavit from a paralegal, basically saying that the paralegal says all we see is black men in here. We don't see anyone else. You have this affidavit. That looks like enough to get you into some discovery. So the district court said, all right, government, you're going to have to throw over some discovery. You're going to have to show us your process along with your procedures, how many people are prosecuted for possession of crack, and how many of those people are white versus black versus other races. The government fought that tooth and nail, and ultimately the district court just dismissed the case. They said, well, if you're not going to comply with the discovery, you don't have a case, and we're going to dismiss it. Well, the government, of course, appealed to the Ninth Circuit. The Ninth Circuit at first reversed, and then en banc, it affirmed the district court, saying that, yeah, there was enough evidence here, and the government did not provide what they needed to allow these defendants to make their argument about selective prosecution. Ultimately, it gets appealed to the Supreme Court, and the Supreme Court overrides the district court and the en banc Ninth Circuit and says, hey, the government was fine here. This does not look like selective prosecution. The defendants did not provide enough evidence to override the presumption that prosecutorial discretion is valid. And so it goes through a few steps to get there. The first step is the court looks at Rule 16 of criminal procedure. Basically, this rule just says that the government has to give over everything that it is using and relying upon, the documents therein, similar to the Brady rule. And the court says this rule, although some are arguing that it applies here, it doesn't apply here. That being because that only applies to the government's case in chief. Selective prosecution isn't part of the case in chief, and so Rule 16 doesn't apply, so it's got to be something else. So then the court delves into selective prosecution. It looks at the standards and ultimately adopts the standard from some of the circuits, not the Ninth, obviously. This says that you have to provide some evidence that similarly situated individuals of another race were treated differently. So if these people, these defendants in this case, wanted to proceed and win here, they would have to show with some compelling and convincing evidence. And I say that, I graph that in. The court doesn't say that directly there. It says in other places. But these defendants did have some evidence. So obviously it's a little bit higher bar than what was produced here. And you have to show that, well, okay, if the government was prosecuting people for crack and the intent to distribute and the possession of it, well, you have to show that some white folks were not prosecuted while black folks were prosecuted, and you have to have some concrete evidence of that. As far as where that line is, the court isn't super clear, but it says that the affidavit of one paralegal and the study therein is just not enough to cross that bar. So ultimately, the court says, for policy reasons, we don't want folks to get bogged down, especially the government with limited resources already, in fighting all these selective prosecution claims. So it's going to adopt a high standard, saying that you have to really have a showing that other people that were similarly situated were treated differently, and it's got to be pretty clear and convincing if you are going to win on a selective prosecution claim under the due process clauses. So with that in mind, it's worth just jumping through the standard of selective prosecution. You have to prove both discriminatory effect and discriminatory purpose, and that's where that comes in with similarly situated individuals. The court, I think one last thing in the majority is interesting. It talks about, just kind of from a separation of powers perspective, and that the prosecutorial discretion, the ability of a prosecutor to decide to prosecute or not, is rooted in the take care clause of the Constitution. And so the judiciary, just, from a separation of powers perspective, is going to be hesitant to infringe and kind of, reach its arm into the realm of the executive, the prosecutor. And Justice Stevens thinks this is a bunch of hoo-ha, and he basically, he's the lone dissenter here. It's 8-1, so the liberal bloc, along with Justice Rehnquist, write the majority, and then Justice Stevens writes a lone dissent. Essentially, he's saying, look, there wasn't an abuse of discretion by the district court. There was enough evidence here for her to see that there was probably some selective prosecution, so why are we overriding her? There was evidence. He says, the court standard is some evidence. Well, these defendants provided some evidence. They provided an affidavit of paralegal that said that we never saw black people prosecuted in federal courts. We never saw white people prosecuted in federal courts. We only saw black people, and we never saw black people prosecuted in state courts. And why is that important? Well, because the federal laws are much harder on crack cocaine than they are on regular cocaine or other drugs than state laws. This was passed by Congress in the get tough on drugs, get tough on crime. President Joe Biden in his era you can see this kind of viral clip of, how we have to have enhanced sentences, mandatory minimums for people that are dealing with crack cocaine. It was really a racist law. And I don't think there's any way around it. The penalties are much more severe for black folks, and Justice Stevens is, just calling attention to that. And he's saying, yeah, you guys said you want some evidence. Well, here's some evidence in an affidavit. It's enough to get through the hurdle. Like, let's make the government show their statistics here, and let's make sure they're being transparent in the way they're prosecuting these cases, and make sure they're not selectively prosecuting them in federal courts where the punishment is going to be much more severe for the defendants. And so that's an interesting case, just to kind of put a bow on it. It is interesting to think about how much power prosecutors really have. A lot of these in the federal government are unelected folks, especially AUSAs. They're not elected. Even the U.S. attorneys, they're not elected directly, right? They're appointed by the president. These folks have a lot of power to decide to prosecute and charge, a lot of power to decide not to, a lot of discretion, and that can be comforting at times. It could also be harrowing at times. So something to think about, something to chew on. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.